The next case is Velden versus Nation Star Mortgage. Are we guys doing? I'm good.
Yep.
Mr. Stope, I hope you don't mind, but we've cut your time down to 15 minutes because of how fast you talk. I know, I like this shirt. Thanks. All right, are you ready?
Yes, Your Honor, may it please the court. I'm Mark Stope, a counsel for the appellant. I would request 5 minutes for rebuttal. Your Honors, I submit there are two reasons why this court should reverse the final judgment of foreclosure. The first issue, based on the statute of limitations, the law has evolved a lot since I drafted the answer brief. And so I want to make sure that Your Honors understand what my position is as I see it now based on the law. I don't think, given the current state of the law, that you can reverse and remand for dismissal based on my statute of limitations argument, the issue I set forth in subsection A. I do think, because frankly there's a lot of cases now that make that clear, you've sort of clarified the limitation on Hicks. So not arguing that issue. But the issue that I think does give rise to a reversal based on the statute of limitations is based on this court's decision in Diamond. The default date in the complaint was February 1st of 2009 and all subsequent payments, but the plaintiff didn't file suit until July of 2014.
Is it fair for me to assume that you don't much care for Justice Lawson's concurring opinion in Bolletary versus Bank of New York Mellon?
You know, I think that's fair, and I'll even go so far, as awkward as it may be, to to argue that a concurring opinion from a Florida Supreme Court justice is wrong, particularly when it was just on this court. But I do submit that concurring opinion is not the law. One, it is not consistent with Diamond. It's not consistent with any of the cases which I've cited in my brief. For instance, Isaacs, Florida Supreme Court decision from 1958. The holding of that case is that the statute of limitations begins running against each payment as it becomes due. That's in an installment contract setting. This court's decision in Lippincott from 1980, the facts there are very notable. October 1973, it was an installment payment, a note. October 1973 was the default and all subsequent payments, but suit wasn't filed until September of 1979, 6+ years later.
Do you need any of those older cases in light of Diamond?
Well, I don't think so, but in the event that you were all persuaded by that, I thought you could, I frankly thought that you could cite, if you were writing a decision on this issue, which frankly I'm hoping you're reversing on the other issue, but you could not only cite Diamond, but cite some of those older cases, because I'll tell you what I encounter on the trial court level right now is I encounter banks who like to try to do what my opponent was here, point to Justice Lawson's concurring opinion and present that as if that's the law. And I think if you were to cite some of those older decisions in a reversal along with Diamond, that it might help some other DCAs realize that Diamond is an accurate recitation of the law and has been for 70-some years.
Well, Diamond, I mean, is there a slight distinction in Diamond? And we acknowledge that the bank agreed that they weren't entitled to monies outside the 5-year frame.
I don't think that Diamond turned on a stipulation. As I read Diamond, that portion where it said that the bank agreed, that was simply the bank acknowledging that that's what long-standing law was. So I don't think that holding turned on a stipulation. I think the Diamond turned on Isaacs and Lippincott and Green and all of the cases which make clear you can't recover on an installment contract when you went on those installments that were due more than 5 years before your complaint was filed.
Payments utilizing Diamond, do you think were covered by the statute of limitations in this case?
I'm sorry, I didn't understand the question.
How many payments do you think are outside the statute of limitations analysis of Diamond in this case?
Diamond, Isaacs, Lippincott, all those cases say that the defaults which are barred are anything from prior to July 24th of 2009. July 24th, 2009 and before, all of that is barred. So all the interest, all the taxes, all the insurance, all those payments from prior to.
About 6 months, right? Because the first alleged default was in January. wasn't it?
Right, so about 6 months, that needs to be lopped off, and that's consistent with all those cases, because the complaint was filed July 24th, 2014, so just go back 5 years, everything prior to that should not have been included in the judgment.
If we lopped off 6 months of payments and interest and otherwise found that the judgment was valid, who's the prevailing party in this appeal for attorney's fee purposes?
I think that we are, because we would have prevailed on a significant issue in the case. That is a significant issue to so significantly reduce the amount of the judgment
When you're arguing on the standing basis that they should get no judgment, right?
well, I mean,
So
obviously, I
if-
prefer
if-
that.
If you don't prevail on the standing issue, isn't that the significant issue? Because they only lose 6 months of payments as opposed to getting the entire case dismissed?
I'd submit not. I'd submit that obviously we're the prevailing party if we were to win on standing. However, I don't think that the way that the law works in terms of prevailing on a significant issue in the case, this is a significant enough issue that we would have prevailed on this. Certainly for the appellate fees, I think we should get.
They prevail on the significant issue that there was standing and therefore they're entitled to the vast bulk of their judgment? Isn't that a more significant issue that they're the prevailing party on?
I mean, I understand what you're saying. In terms, I think the way that I see it in my head, if you were to reverse only on the statute of limitations issue, that they should get the lower court fees because they won on the foreclosure, but that we should get the appellate court fees because we prevailed for purposes on a significant issue in the case by getting that lopped off on the
So even if we were talking about a 1 month as opposed to a 6 month difference, if we say, okay, we're going to follow Diamond, we just released that a few months ago, Justice Lawson acknowledges he has no precedential value, although he does kind of, give a shot saying, but you guys can think this over if you really want to. Your view then, if it was 1 month or 2 months as opposed to 6, you'd still be the prevailing party on as to appellate fee issues?
Well, I mean, that's obviously a harder call.
Well, I know, that's why I asked it.
I
Get the rule, right?
I mean, it's, frankly, if that's what this comes down to, I'd ask for a chance to write a memo on that issue. That's not something that either of us briefed, and it's been a while since I've read some of those cases. So if you're interested in a memo on that, I'd be happy to draft one up on what it takes to be the prevailing party.
If you'd made that the only issue in the appeal, it would be obvious, right? If you had chosen just to bring the statute of limitations issue here, you'd have a much stronger argument than including an argument that you're asking the entire judgment to be thrown out, right?
I think that's fair, sure.
And
Now,
we're not going to ask for a memo. We'll give you a memo.
fair enough, Judge. But, Your Honor, let's talk about why we shouldn't be having to answer that hard question, because I think I should be winning on the standing issue as well. Standing at the inception, you had Freedom was the original plaintiff, and then there was a substitution during the pendency of the case, such that Nation Star was the plaintiff at the time of trial. It's very clear that there was no documentary evidence that Freedom was in possession of the note at the time the suit was filed. The Bailey letter, which existed, was postdated the filing of the suit, so that doesn't help them. There was no screenshot, notes log, anything like that. This court's decisions are clear on that issue. Walsh decided earlier this year, Gonzalez, Schmidt, the cases are clear. This court requires documentary evidence of standing. That was.
Did Cummings testify that Nation Star possessed the original note prior to the trial?
I don't think so, but even if that did exist,
Go to page 206 of the record.
That's.
And then give me another answer to that.
That's, even if that is their judge, my main point is that is not, and I'll look at that during the break, that is not documentary evidence of standing.
They had the original note, right? The original mortgage, composite of the first and second assignments of the mortgage, the payment history, the hello, goodbye letter, the April 2009 default letter, a Bailey letter, and all of those came into evidence by stipulation.
Okay, but Nation Star's possession of the original note and any testimony by a Nation Star witness isn't documentary evidence that Freedom was in possession of the note at the time the suit was filed. That's what this court's precedent clearly requires. And in the Gonzalez decision, even when there was testimony that the note was possessed at the time the suit was filed, you still reversed, saying that there had to be documentary evidence. There clearly was no documentary evidence, which is what I concentrated on in the briefs, no documentary evidence that Freedom was in possession of the note when the suit was filed at all. And so as a result, and my opponent doesn't even argue that issue, instead what they argue is application of the what I call the Ortiz presumption. Well,
Explain why you think the Ortiz presumption doesn't have the same effect if there are some subsequent transfers of the documents.
the whole point of Ortiz is the 4th District said when PNC Bank comes to trial with the original note, hands it to the court, and PNC Bank attached an identical copy of that own note to its own complaint, then we can presume that PNC was in possession of that original note when the suit was filed. PNC's here with it at trial. PNC attached an identical copy to its complaint. When there's a substitution of party plaintiff during the pendency of the case and the note changes hands, you necessarily can't make that presumption. You can tell that by the Bailey letter. The Bailey letter, which is introduced into evidence, shows that Nation Star was in possession of the note during the pendency of the case and gave it to counsel. So when you have Nation Star coming to trial with the original note, you don't have any basis to presume that Freedom was in possession of the note at the suit was filed. It might have been in possession of the original. It might have been in possession of a copy. I made a lengthy analysis in the initial brief about the circumstances where evidentiary presumptions like this should apply and should not apply. A lot of it was based on Earhart. And I submit there's simply not anything that allows a Florida DCA, as opposed to the legislature, to essentially create an evidentiary presumption that doesn't exist on in the legislature through a fact pattern like this and say, well, Nation Star possessed the note at the time of trial, so we're just going to presume that Freedom did at the time the complaint was filed. Where the note changed hands during the pendency of the case, you can't make that
What about
presumption.
the presumption in the Ortiz context, then? Are you saying that's an invalid presumption, too?
Yes, the presumption only applies when the party is the same.
But even there, are you saying that's a presumption that's improper for the courts to imply, that if we want that presumption, that should have been passed by the legislature?
Frankly, I think that it is. Now, I don't think I'm going to win that argument because there's so many decisions that have applied that presumption at this point. But the reason that I made that analysis just to say the presumption I submit is that...
What's different about that presumption from this other presumption that would make one of them valid and the other one not valid?
Well, you're extending it even further, okay? And there has to be limitations on the Ortiz presumption, and Friedel illustrates those the limitations, which I'll get to in a second. But I submit it's already a thin presumption anyway. We're already treading on thin ice by applying the presumption at all.
There are theories or arguments why even in the Ortiz case you could make an argument that that doesn't prove that Ortiz had it in its possession on the day of the filing, right?
You could, but let me get to Friedel now, ties well into this. In Friedel, the 4th District, the same court which created the Ortiz presumption, said the copies have to be identical. And the bank asked, and I asked that your honors compare page 23 of the record to page 185, the copy of the note attached to the complaint versus the original note introduced into evidence. They are not identical. You can see by looking at them, I don't know if you can see this, the black lines, the black bars in my right hand on the top of the note that was attached to the complaint do not exist on this here. Now that might sound like a technical difference, but that is the exact fact pattern that Friedel dealt with.
You're going to argue a technical...
I would never, Judge.
Oh, all right. I just wanted to make sure that...
Now, the reason that matters and why the 4th District ruled that way is because we apply the Ortiz presumption when the copy that's attached to the complaint was taken from the original. And if they're not identical, then you can clearly show, it's pretty clear that the copy attached to the complaint was taken from another copy as opposed to the original. So you apply the Ortiz presumption on the fact pattern where PNC comes to trial with the original note and the copy attached to PNC's own complaint is identical, because in that circumstance you can tell that PNC made the copy which is attached to its complaint from the original. Here,
that argument made in your brief?
Friedel didn't exist at the time, but I did argue in both briefs that the Ortiz presumption should not apply.
Did you argue that the note was not in the same
Yes.
The notes were not identical.
Argued that the Ortiz presumption only applies when they're in the same condition, and they weren't in the same condition. Now, I didn't argue the black bar issue. Frankly, the Friedel case didn't exist at the time that we did the briefs. But that's the bank's entire argument, is to presume that they possessed the note merely because it was attached, and their argument was expressly rejected by the 4th District. And that Friedel decision went in bank. The entire 4th District considered that issue, and they nonetheless issued a decision which rejected the concept. So the bank's entire argument is an argument that the 4th District has expressly rejected because those documents are not identical. And you can tell that the copy attached to the complaint was not taken from the original. So what you have here is they have no documentary evidence of standing at all. They're asking you to infer possession of the original note based on a presumption, even though there was a substitution of party plaintiff during the pendency of the case, and we know that the note changed hands, and where the copy which is attached is not the same. Two circumstances.
I'm looking at the summary of your argument on this issue in your brief, in which you say, the court should also reverse because Nation Star did not prove Freedom possessed the note at the time of the complaint. Though Nation Star relied on a presumption set forth in Ortiz, the Ortiz presumption does not apply here because the note changed hands during the pendency of the case. In other words, Nation Star came to the trial with a note endorsed in blank, did not prove Freedom possessed the note at the time of the complaint. That doesn't sound like an argument that the two documents are different. Your only argument here seems to be they don't get the presumption because it changed hands. Where's the argument that, and they're not the two documents aren't the same, and that's why they lose?
Can I point out the best lines to you in my rebuttal argument?
Absolutely.
Thank you.
Good afternoon, Your Honors. Eric Levine of Ackerman LLP on behalf of Appellee Nation Star Mortgage. May it please the court. Counsel's conceded the first issue, whether the entire action should be dismissed as barred by the statute of limitations. It's timely. So moving to the argument he made that, well, even if it's timely, you have to lop off 5 years of payments. That is completely inaccurate.
5 or 6
5 months.
I'm sorry, 5 or 6
Why
months.
don't you lop off
Yeah,
5 or
5 or
6
6
years?
months for the payments that came due more than 5 years before the action commenced. That, first of all, I'm going to point out in all candor to the court, that argument's not preserved for appeal. That argument was never raised below. The trial judge specifically said, do you have any objections to the amounts?
Well, but
and this
the
is on
law
page
has-
248.
The law changed, there's case law that's come out
True.
since the
True.
briefing of this case.
True, but fair enough. But even if it were preserved, Diamond, as Justice Lambert pointed out, Judge Lambert, I'm promoting you too quickly. Judge Lambert pointed out, was on consent. In that case, U.S. Bank said, we agree to remove these payments. That was their decision, and this court accepted their agreement and said, okay, remand. The Diamond discussion was 2 sentences. They agreed on remand, remove it. That is not a adjudicated analysis of the issue. The statute of limitations is a threshold issue as to whether or not the cause of action is timely. Once we determine that it's timely, which we have here, that's it. We never talk about it again. Federal District Judge Dalton, about 2 weeks ago in a case called Green, addressed this, citing Bartram, citing Justice Lawson's concurrence in Bolletary. He said, quote, each missed payment creates a new cause of action for the full amount owed, and the lender's right to bring the cause of action is non-waivable. He further went to say the statute of limitations, quote, does not reduce the amount owed. It simply requires that lenders bring suit for all amounts due within 5 years of the date on which the cause of action accrues. To reach the conclusion that counsel is trying to get this court to go, not only do we have to torture the statute of limitations from a claim-based analysis into a damages-based analysis, we have to rewrite the mortgage, which says all sums due under the note are secured, to say only sums due less than 5 years ago are secured. We have to further rewrite the non-waiver provision, which says forbearance doesn't waive any rights, to say forbearance does waive your rights. And we need to rewrite the provisions of the note and mortgage that say when an acceleration is declared, all sums...
So we take the bait from Justice Lawson, we're going to take this whole issue of statute of limitations outside of our mortgage foreclosure appellate litigation, aren't we?
Well, Justice Lawson was discussing that there's
Yes,
a,
that's a good idea, Judge Lambert. I wish you guys would do that. Was that, I heard you say that?
Justice Lawson,
Oh, okay.
Justice Lawson was basically saying there is a special rule. He said there's a special rule for mortgage foreclosure. When you,
He says there's a long-standing rule from 1925 ALR article.
the statute of limitations commences, the cause of action accrues when the loan is accelerated. And when the loan's accelerated, that means all amounts are due unless you want to rewrite the party's
Purpose of
contract.
the statute of limitations.
The statute of limitations is to allow you to bring a cause of action within 5 years of its accrual. But in an installment contract such as this,
And is that in part because evidence gets stale, memories get, impacted? Isn't that really
That-
what? So under your theory, if I have a 30-year mortgage, you could wait until year 29, month 11, and then bring an action for foreclosure saying that I failed to make a payment 29 years, 11 months ago. Hypothetically, you could do that.
Or even to 34 years and 11 months, because you got 5 years after it accrues, right?
yes, yes, that is correct.
And you don't think that offends the concept of the statute of limitations?
It does not offend the offends the concept of the statute of limitations because the statute of limit accrues each month the payment missed, and the statute of limitation accrues again when the loan's at maturity. The parties contracted for a
If I only
30-year
missed one
relationship.
payment? What if I only missed one payment?
29 years ago.
Well, then the amounts that were due, if you've made every payment since, then you wouldn't have a big lop-off issue if you've made all your payments for the last 29 years. If you're talking about a situation where you just missed one payment and you've been, if that occurred,
Just say, under
if that occurred,
under your analysis of...
that's not how payments are applied, though, Your Honor. If you missed a payment 29 years ago and you've made every payment since, all the payments will be applied chronologically. So theoretically, the missed payment, according to the plaintiff, would just be the one from a month ago, not from the one 29 years ago. So that situation would never come
That's
up.
an accounting concept.
But that's not how it would play out.
Well, I'm just giving you that as a hypothetical to understand your argument on the statute of limitations.
The statute of limitations has nothing to do with damages. It has only to do with whether your cause of action accrues, and that's what Judge Dalton
The purpose
said.
of it is so that you can have timely notice of a cause of action, and you don't have to wait until memories are gone, evidence is disposed of, people have passed away.
But there's no allegation, at least in this case, that occurred. The bank records are in evidence. The witnesses testified as to the procedure.
It's the theory.
That would be the theory behind the statute of limitations, but in a sense, the statute of limitations still runs from when the cause of action accrues. And the cause of action accrues, according to Justice Lawson, at acceleration, or at the very least, it accrues when the payment's missed within the past 5 years.
Under your accounting theory, then Diamond is incorrectly decided.
Well, I would say that Diamond didn't actually decide that issue. Diamond was just, the parties agree to waive the payments that came due more than 5 years before case inception. It never actually adjudicated the issue. The fact that U.S. Bank decided to waive it is fine for them, but shouldn't be binding on everyone else just because they decided to waive those payments. So, and that's what the contract provides. So the overriding policy is to enforce contracts according to their plain terms, and that's what the contract provides. And there's no inequity to enforce a contract as written, and when a parties have contracted for a 30-year relationship, to honor that 30-year relationship, which is why amounts, no matter when they came due, are still secured by the mortgage and are all included in the final judgment. And I remind the court that a final judgment of foreclosure is not a money judgment. It's not a judgment awarding money. It simply determines the amount secured by the mortgage lien and sets the right of redemption, but it's not actually awarding a money judgment, which is what the Supreme Court said in Bartram when it talked about future foreclosure actions being filed. It says the bank could, quote, seek acceleration of all sums due under the note. That's what Bartram said, and all means all. There's no basis to rewrite the party's contract and reduce the amount of secured lien because counsel and the appellant just want the court to do so. Moving on to the standing argument, counsel overlooks the Glicken case out of this court in October of this year, which is exactly on point with this case. In Glicken, Wells Fargo commenced the action, attaching a copy of the note endorsed in blank to their complaint. U.S. Bank was later substituted in as plaintiff. U.S. Bank shows up with the note at trial, which is identical to the facts here. This court held in Glicken, and I read, quote, when the note with an undated blank endorsement has been attached to the original complaint, this is sufficient to prove standing, provided that plaintiff produces the original note at trial or files it with the trial court with the same endorsement, and there are no subsequent contradictory endorsements, which is identical to what we have here. And even putting aside Glicken, which is kind of based on the Ortiz progeny, there was documentary evidence of Freedom's possession at case inception. Freedom put that blank endorsement on it. Freedom could not have endorsed the note if it was not in physical possession of the note. And in the reply brief on page 5 and 6, the appellant concedes that. He concedes, okay, well, yes, there was proof that they were in possession. Well, we just didn't know if it was on the date that the complaint was filed. There are two problems with that argument. The fourth DCA rejected a very similar argument, a case called Pisano, where the original lender was also the original plaintiff. Later, Ocwen substituted in. And they said, well, there's no proof that the original lender still had the note at the time of they filed the complaint. And the fourth DCA there said, quote, because the record contained no evidence that the note was transferred, we must conclude that GMAC remained the note's sole holder from the loan's origination at least through the filing of the complaint, which is what we have here. And I further point out to the appellant's admission on page 6 of his reply brief, which says, given the evidence adduced at trial, Freedom may have possessed the original note at the time of the complaint, but the evidence was equally consistent with the proposition that a different entity possessed the note at the same time. Well, if we have two versions of what happened, both supported by the evidence, the trial judge makes a factual determination, and this time the trial judge made the factual determination that Freedom was in possession. That's competent substantial evidence, which is not subject to being reweighed on appeal. So the argument as to standing, I believe, are not well-founding based on this court's decision in Glicken and the actual evidence that Freedom was in possession of the note prior to case filing. With that said, Your Honors, I have about 10 minutes left, so I'd love to answer any additional questions on standing or amounts due and owing, but we ask that the court affirm the final judgment as is without any remand for removal of any amount secured by the mortgage lien.
All right, thank you, sir.
Thank you.
May it please the court. Your Honor, I've taken a look at page 206 of the transcript, and I stand by my original answer. I don't see anything there where there's testimony that the original note was in the possession of Freedom at the time the complaint was filed. I think the line that you're looking at asks about in NationStar's possession prior to coming here to court today on lines 12 through 15. I don't see that there's any testimony that Freedom was in possession of the note at the time the suit was filed. That's why my opponent is relying upon the Ortiz presumption. But if you look at Glicken, the case that he harped on there so strongly, in the second to the last paragraph, which are identical to the copies that were attached to the foreclosure complaint. The original note and allonge, which are identical to the copies which were attached to the foreclosure complaint. Every case that you'll look at that applies the Ortiz presumption has some sort of language like that the copies are identical, that the copy attached to the complaint was identical. Now getting to Your Honor's question, page 16 of the answer brief, there is no question that the surrendered original note here was, quote, in the same condition as the complaint copy. Compare record 23 to 25 with 185 to 187. That's exactly what I asked you to do when I held up both copies, is make the very comparison that the bank put in their answer brief. And then on page 24 of my initial brief and page 5 of my reply brief, I'm not, at no point am I conceding or take anything like that on the issue that those are the same. They're trying to take the position that the copy attached to the copy of the note attached to the complaint is the same as the original. It clearly isn't. You have Friedel, which is right on point, which my opponent doesn't even address at all. Doesn't even try to say that argument is wrong. Has no argument on that at all. Left 10 minutes on the clock and ignored that argument. You have a DCA decision which is right on point on this issue, and you know I've presented this to this court as where's their documentary evidence of standing at the inception. They didn't present any. They didn't have anything. They said nothing. They rely on the Ortiz presumption, presenting Glicken, and I've shown how Glicken is clearly distinguishable, and they don't really have an argument on that, and don't have an argument on Friedel.
Where's the statement? Did you say on page 24 of your initial brief about them not being identical?
I guess has so many briefs here. It was on page 5, it's on the reply brief, it's the end of the first paragraph, and it was on page 24, it was near the top.
At the end of the first paragraph of 5, where's the argument that the documents are different?
What I say is there's a lengthy explanation that's summarized, but the Ortiz presumption cannot be applied on these facts. And then
That's not what I asked, where you made the argument that the two documents were different in any of your briefs. Did you make the argument in any of your briefs that you're making today that this document, if you look at it, is different than this document if you look at it?
I don't think that like the way that you just said that, I don't think that that's here. I also don't think that's fatal, given the way that this has been presented.
If your argument today is the reason why we should find in your favor is because this document doesn't match this document, then it seems to me that's an argument you had to have made in your brief.
Well, Judge, Your Honor, a couple things to that. First, we're arguing the Ortiz presumption shouldn't apply at all. We argued in detail on why the Ortiz presumption...
Because there was a subsequent transfer. You didn't argue because the documents are different, right?
I argued it shouldn't apply at all based on the evidentiary presumption not being something that you should be doing.
You argued that it shouldn't be applied according to your summary of argument because of the subsequent transfer.
I agree with that.
You didn't argue anywhere because the two documents are different.
I think that that's inherent in the way that the briefs are presented, especially as you're looking at page 16.
There you have it.
Now, I also submit with my last 20 seconds that substitution argument is well taken. What's your basis to conclude where there's a substitution that the original plaintiff had possession of the original note merely because NationStar had it at trial? That doesn't prove anything. That doesn't prove the issue. So I submit you should be reversing on that basis. And the
Mr.
Glicken
Stowe.
decision doesn't address
Thank you,
that
Mr.
issue
Stowe.
at all.
Your time's up.
Thank you, Your Honors.
All right. Everybody, okay.